Okay, let's get right into this video. We are live. My name is Attorney Walter Rudolph Hnot, the third of Disability Resolution PA. Please remember to hit that like button because that's how other people will be able to see this video. Now, here's the bottom line with this situation. These are essentially the statements that an administrative law judge, a disability judge, will likely say if the judge is leaning in the direction of a potential approval. Approval for disability benefits comes at the ALJ hearing level in a couple of ways. It could be from the bench. They're telling you right then and there from the bench that they're going to approve you. It could be in letter form down the line where it says partially favorable or fully favorable in a letter. Now, what is a partially favorable? Partially favorable is where they're moving your alleged onset date but still approving you. Fully favorable is when they're approving you from your alleged onset date. Let's get right into it real quick. All right, now, all these statements must be stated at the end of the hearing to still be valid. And all of these statements must be specific to the claim in total. It can't be about like one little thing here, one little thing there. It's got to be about the claim in total. So just bottom line, not every disability judge will use these and they'll still approve you. So for the person in the comments who's like, oh, my judge never said those, but they still approved me. Of course, these are just heads ups when the judge wants to say, hey, it's going to go this way. I'm going to prove this way, okay? Also, there are variations of these statements, but this is the more general overall version of those statements I'm going to be giving you, okay? Please remember to like. Please remember to subscribe. Hit the all button, though, because they don't tend to put my videos in the suggested list. All right, let's get right to it. Number one, I'm going to help your client out today. Okay. They also say, I'm going to help out your client today. The whole point of this statement is that at the end of the hearing, when the judge says, well, all right, counselor, I'm going to help out your client today. That is a big green light to the disability attorney to say, okay, this is very likely to be an approval. I will now go ahead and explain what happens with an approval to the claimant because they're going to be going in that direction. So once again, the judge will say, I'm going to help out your client today. Okay, looks like I've reviewed the evidence. I'm going to help your client out. That is a very, very good statement that you want to listen for in a Social Security hearing. Now let's get to question number two. I will agree to that amended alleged onset date based on the medical evidence in or at 15F, 2F, 5F, 23F, whatever. It's in the F folder. It's medical documentation. Medical documentation is always in the F folder. A, B, D, E, F. There's no C folder anymore. All right, cool. Let me go through that real quick. I will agree to that amended alleged onset date. They're agreeing to the day they feel you became severely impaired. So you sent in an amended AOD. The judge reviewed it, saw the attorney's arguments as to why they liked it. The judge agreed to it. And then they'll say, I'll agree to it based off of that 15F, and then they're going in reference to an exhibit number for the medical documentation. In that sense, in that equation, that judge is giving the nod to the attorney because the claimant's not going to know what the heck is going on. But the judge is giving the nod to the attorney that the judge, this disability judge is likely to approve the Social Security claim for benefits at the OHO hearing level, Office of Hearing Operations hearing level. Cool. Question number three, and please remember, don't be stingy with those likes. Don't be stingy with them. I do believe the claimant is severely impaired based on their work history, and the medical evidence is sufficient. Okay, so this one is a little bit more complicated. Let me walk you through how it works. I do believe the claimant is severely impaired. Cool. Element 3, approval. This means that, okay, they believe that the claimant meets severity or potentially can't work with a vocational allowance approval at element 5. Cool. Based on their work history. Okay, so the judge is saying element 4, past relevant work. It looks like they truly couldn't work. It looks like they attempted. It looks like they had failed work attempts, unsuccessful work attempts. Looks good. Then the latter part of this. And the medical evidence is sufficient. Okay, so never forget, the judges, when they do their analysis, they have to write in why they want to approve this claimant. So they need stuff in the medical evidence to tick off, right? To check off, if you will, to go ahead and put into their analysis. I believe the claimant is disabled because this thing, this thing, this thing, this thing, this thing. Like the major thing that a lot of people that are like, we call them lay people, they're not attorneys, what they don't realize is that everything has elements and all those elements require bullet points from the facts, right? The judge or the doctor said this, the claimant said this, the officer said this, right? So these are the bullet points that we use as part of our analysis to fill in essentially why we believe this should come out that way. So once again, I do believe the claimant is severely impaired. That's good. Based on their work history, we're beating off element 4 there. So element 4 is past relevant work, the jobs you've done within the past 15 years. So we're getting rid of that one. We're good on there. And the medical evidence is sufficient. Now, what does sufficient usually mean? It means usually there's enough of it, or there's a statement in it that is very specific for a type of impairment that is like a checkoff. Like when the Blind Institute says the person is blind, check, done, right? So the bottom line is, and other ones are much more difficult than that. Obviously, like anxiety and depression, it's, you have to show continuous repetitive medical problems. You have to show all these issues, appetite disturbance, basically difficulty with sleeping, difficulty with interacting with others, all that kind of stuff. But the point is, when medical evidence is sufficient, right? The judge is saying, okay, I've seen the medical evidence. We got a lot of Baker Acts in here. We got a lot of severe notations where they had to be overnight at a medical facility or a behavioral facility. This looks good. That sentence right there, I do believe the claimant is severely impaired. Cool. We know element 3 or element 5 vocational allowance. Based on the work history, past relevant work, element 4, out of the way, we're good. And the medical evidence is sufficient. The judge has enough medical evidence to bullet point the analysis so that when the judge has the writer write the brief, the writer has enough to go ahead and back up an approval. Cool. Let's go to element 4, or let's go to question 4 now. I think we are okay based on the DLI for a sedentary grid out option. Okay, so I think we are okay based on the DLI for sedentary grid out option. So, okay, what does this mean? When the judge says, I think we are okay, what the judge is really saying is, looks good to me. Looks good to me. Should be okay. Should be good. I think we are okay. Should be good. Looks good. I feel that it's sufficient. Based on the DLI, the date last insured, right? So basically the DLI is forward enough in time that you're still covered for SSDI benefits. For a sedentary grid option, so we're talking about basically an individual who, essentially is, potentially, 50, it's a little tricky, but 55 plus, definitely. So the bottom line is, I think we are okay based on the DLI, and it's really for a 55 plus, or I have no issue there, for a sedentary grid option. I mean, you could do a 50 in there as well, but point is, I think we are okay based on the DLI, day less insured, for a sedentary grid option. So what are grids? I did a huge video on them, but basically what grids are, you go ahead and have the person's prior work history, the person's education level, whether or not they have transferable skills, sedentary, light, medium, heavy, very heavy, and then it's like this grid, right? And if you match up with the grid, then you can be found disabled based off of an option. There are options where you do not get found disabled. So that's the bottom line, is that when the judge says, okay, looks okay for this potential grid out, that is a very strong sign to the disability attorney to then have that chat post-hearing with the claimant that the judge is likely to approve the claimant. Okay. Number 5, I'm making a ruling from the bench. Talk with your attorney afterwards, and they will explain to you what this means. Now, a weird thing is happening where disability judges are now saying, and I've heard this twice now, and this is more of a recent thing, where they're not supposed to make a ruling from the bench. This is like a newer thing. They used to do it very rarely, but they would do it, and there was no like, oh, I can't do this. But the judges have said, I'm not supposed to make a ruling from the bench. So that's like a new statement I'm hearing. It must be a way that they're training them. I'm not sure. It could have just been 2 of these judges doing that, but it was within a short period of time. So it could be part of their new thing. But the bottom line is, I'm making a ruling from the bench. They never really make a ruling where they're going to deny you from the bench, right? They never tell you, hey, I'm just going to deny you in the hearing, right? They always leave it like open for the potential of an approval, right? Otherwise, the claimant would start acting out and being aggressive and things like that. So if the judge says, I'm making a ruling from the bench, that means very likely approval, because the judge is not going to negotiate with the attorney over the AOD right then and there. The judge will, option A, call the attorney directly after the hearing to negotiate the AOD, or call the attorney months or weeks after the hearing to negotiate the AOD. But if it's on making a ruling from the bench, the judge is accepting the AOD as was amended or in the actual file. Talk with your attorney afterwards, and they will explain to you what this means. So a lot of people, obviously, if you don't have an attorney, none of this is going to be super relevant to you in that question, because the judge is going to know that you have nobody to rely on when it comes to like explaining what's behind the words for phrases that usually mean something. I mean, now you have 4 out of the 5 that you can go by, but this one, the ruling from the bench, you can use that one too. That's where basically the judge is going to make a ruling in your favor, and they're deciding it from the bench, from that hearing at that moment from the bench. So talk with your attorney afterwards, and they will explain to you what this means. And so what that is the judge is saying, okay, cool, I'm gonna help your claimant out. I'm gonna approve the claimant. I don't want to say that directly to the claimant, so I'm going to have your attorney go ahead and explain it post-hearing. There's a couple reasons for that. Number one, the claimant will usually have a bunch of questions if the judge says, I'm going to approve you, which the judge doesn't want to get into. Number two, the judges realize that it's always nice for the attorney to have a celebratory moment with the claimant. Number three, claimants do a lot of weird stuff, just weird stuff when they find out that they're going to be approved for benefits. I realize that a lot of people are like, well, of course we are. We've just waited so many years to be found disabled. Of course we are. Yeah, but you gotta remember, we do hearings all the time. Judges do more hearings than the attorneys because they're constantly sitting in hearings, right? They're not like meeting with clients, prepping claims, doing DDS stuff, etc. So keeping the flow rolling, getting from this claim to this claim to this claim to this claim to this claim, getting through the day is important. One of the major things that's becoming more and more apparent for the judges is the unhappiness of the clerks that are like, typing up what's going on. Because, if somebody doesn't show up for a hearing, they don't get paid as much. If they have to, postpone a hearing, or if it's one of those things where the claimant is late or the judge is late, those hearing reporters that basically, click, 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 type stuff up, they get very cranky because the day just slows down and slows down and slows down. And the judges are becoming much more aware of what's going on with the emotional state of other government employees that are potentially in the room. The younger the judge, the more aware, like emotionally connected they are to the needs of the other players in the room. Okay. The old school judges, pretty much zero shits could be given, to some degree. I mean, there are some that care, but a lot of them, it's zero shits. You know what I mean? So the bottom line is that these judges are aware, like those people, the typing clerical, clerks, they don't really make that much. So when instead of having to be there for like, let's say 8 a.m. until like 3, or no, like 8 a.m. to 2 or 2:30 or whatever, and they've got to then go until basically like, 5, then that's a huge burden on somebody who already doesn't make that much more money when you're getting paid per claim. So that's kind of the heads up that you need to know about with that. So I'll go through the questions again. I'll summarize them real quick. These are 5 statements disability judges make when they likely will be approving you for Social Security benefits at your disability hearing, whether for Social Security disability insurance or supplemental security income, but based on disability. And remember, it has to be as a statement at the end of the hearing where the judge is making it. And it can't be about one little specific thing. It has to be about the claim in total, right? The whole friggin' thing, not just this little thing like right there. It has to be the whole claim in general. So here are the questions. 1, I'm going to help out your client today. Very good thing to hear. Common phrase when they want to approve it. Number 2, I will agree to that amended alleged onset date based on the medical evidence at 15F. Could be 2F, 32F, 1F, 4F, whatever. 3, I do believe the claimant is severely impaired based on their work history, and the medical evidence is sufficient. 4, I think we are okay based on the DLI for sedentary grid option, or they'll say a sedentary grid out, right? So I've noticed that the older judges will use like a grid out, and then the younger judges will say like grid option. So I don't. There's no importance to that statement. It's just other than when you hear grid, that's the word you want to focus on. Number 5, I'm making a ruling from the bench. Talk with your attorney afterwards, and they will explain to you what this means. Okay, so those are essentially the phrases that if you hear them during a Social Security disability hearing, you're more than likely heading towards the train of an approval, right? You're on that train going towards an approval. Now, with that said, a lot of people are very confused, and I'm going to do a mini disclaimer and then get to the next video. A lot of people are confused essentially about the vocational expert portion of the hearing, because when the vocational expert says there's no available jobs in the economy, claimants automatically go, yes, job will fist bump, right? And the truth is, judges will usually ask, unless it's like clear that they're just going to absolutely deny it, judges will usually ask a question that gives them the option, opens the option of saying, okay, what if the person's going to be 15% off task during the day? What if the person's going to be, missing work 2 times, a month, 2 days a month of the year? And so, and then, or, two days per month of every month of that year. Then it's clear that that person is essentially going to be terminated from any job in the national economy. And then, boom, no job available in the national economy. But that doesn't mean de facto that the judge will choose that hypothetical option. Okay, the judge will usually give, him or herself basically 1 or 2 options, so that when they go to write this thing up and they find something they don't like, they can go this way or they can go that way. All right. Again, guys, it is super late, 12:07 a.m. I have to wake up early for Monday morning calls and catch up on all the emails and text messages. Please remember to like. Please remember to subscribe. Click the all button. Also, if you want to leave a review on Google, that's fine. I love waking up to those 5 stars. But basically, you just go to Google and you type in Disability Resolution Florida or Disability Resolution, law firm. Sorry, I'm super tired. Other thing that's important too, we're going to be doing a membership setup in the not too distant future for this channel. All the same videos that you guys are used to will be popping up in the normal way, but there will be additional video options as well to capture that members can go ahead and grab. Now, with that said, if you need a disability attorney, I will be catching you guys a little bit later, hopefully. You can always give me a call and we'll go from there. Have a wonderful, wonderful day, and thank you so much. All right, bye-bye.